All right, everybody, looks like we are live. Looks like our audio and visual are all working good. If not, just go ahead and let us know. You can put that into the chat on YouTube if you'd like. I am George. I'm one of the co-founders of Solo Suit. We are here to help you guys win your debt collection lawsuits. We've also got Karra Kingston here with us. She is the debt lawyer on TikTok. Karra, you want to go ahead and introduce yourself and tell us a little bit about what you do?
Yeah, so my name's Karra. I'm an attorney. I practice in bankruptcy in New York and New Jersey, but I also bring FTCPA claims against debt collectors in many states. For bankruptcy purposes, is only in New York and New Jersey because that's where I'm licensed, but we have local counsel who brings cases under the FTCPA in many other states. Yeah, that's basically a little bit about me.
Awesome, great. Go ahead and tell us a little bit more about bankruptcy, how that works, and how someone can figure out whether or not they should look into bankruptcy.
Sure. So normally a lot of people who come to me are very upset that they have to file for bankruptcy and they think that their life is ruined. Filing for bankruptcy is a tough decision to make, but it doesn't mean that your life is ruined. And I think one of the biggest misconceptions that need to be out there is that filing for bankruptcy will give you a fresh start. And the laws were enacted to give people a fresh start. So they're there to really help people. But I understand that for people, it's detrimental that they have to file for bankruptcy. Many times, a lot of people that I see are people who have been in, have immense amount of medical debt, are in divorce. So they built up a lot of debt. They lost their jobs or started a business that didn't work out. So those are the types of people that I see. It's not really people that just charge up their credit cards and then decide that they're going to file for bankruptcy. So I think that's really important. Usually when to consider bankruptcy, it's usually when your expenses really outweigh what you're taking home. If you cannot make minimum payments, you can't settle your debt, you can't try to work out anything with your creditors, at that point it's probably time to look into filing for bankruptcy. If you're getting a bunch of judgments against you and you're not able to hire an attorney or use Solo Suit or file an answer and you're getting 20 of them, it's probably time to think about or consider filing for bankruptcy. There's two chapters of bankruptcy. There's Chapter 7 and there's Chapter 13. Chapter 7 is for people who have less income and no assets, and usually that will give them a clean slate. Chapter 13 is more for people who have assets and who have assets that have equity and a high income, and you go into a repayment plan. But in that repayment plan, you may not be paying all of your debts back, and also the interest and fees stop accruing. So that's how that may help somebody who's looking to file for bankruptcy. It also stops any garnishments that have come in. So immediately when you file, there's an automatic stay that goes into place, and that will cease any collection activity from debt collectors. So that can be helpful as well. But that's pretty much how the bankruptcy process works and when you should start to consider filing for bankruptcy. And most attorneys give free consultations. So you should, take that to your advantage and maybe call around and see if you can get some free advice from attorneys who would go through your circumstances and decide whether bankruptcy is a good option for you.
Okay, great. Thanks for giving us that overview, Karra. I love it. Folks, we have a lot of listeners on here today. If you have a question, we reserve most of the time here for Q&A, so whatever your questions are, go ahead and put those into the chat on YouTube. Whatever question you might have, put it in there. If you have a question about how to deal with your debt collection lawsuit, how to win it, or if you are considering bankruptcy, if you have any questions around that, like what it looks like, if you should do it, go ahead and put those questions into the chat as well. All right, we're here to help you out. Karra, I think one question that people have is you mentioned that you do FTCPA claims.
Yes.
What does that look like? When should someone try to do an FTCPA claim? When do they have an FTCPA claim if like some debt collector is violating something?
Yeah, so under the FTCPA, Congress enacted this statute to protect consumers who are in debt. So a lot of times debt collection letters from debt buyers who are like portfolio recovery, Midland funding, there's a bunch of them. If you're getting debt collection letters, you may have a claim under the Fair Debt Collection Practices Act. So what the Fair Debt Collection Practices Act does is allows a consumer to sue a debt collector basically for free. Attorneys take these cases for free because there's a fee shifting statute, which allows the attorney to get paid and the consumer pays nothing. You can be awarded up to $1,000 in statutory damages. You may get a debt waiver, and you also may get the trade line deleted off your credit report. So inadvertently, it kind of gives you some credit repair. I'm not a credit repair attorney, but that is helpful for people. A lot of the violations can be the debt collector harassing you, threatening you. Debt collectors can only call you once within a 7-day period. Sorry, 7 times within a 7-day period. So if they call you more than 7 times within a 7-day period and you have that record, then that will be a violation. There's certain hours that they can call you. They can call your friends and family, and this is a big one, but they cannot disclose your debt to your friends and family. So that's another violation. And the biggest thing, though, is that these debt collection letters a lot of times have violations that we've seen. And a lot of consumers don't understand or don't know what those violations are in those letters. So it's really important not to throw out your debt collection letters because you may have a violation. And if you do, you have the shot of maybe getting some money back or a debt waiver or a trade line deletion. So it's really important to save your debt collection letters and have an attorney review them.
Okay, so save your letters, have an attorney review them, find out if you have some kind of a claim. Great. We got a question coming in from Grant here. How long does bankruptcy usually take?
So it depends what chapter that you are doing, but if you are doing a chapter 7, typically 4 months from beginning to end. If you are doing a chapter 13, it does last for 5 years. So that's the 5-year repayment plan. But chapter 7, typically 4 months.
Chapter 7 is only 4 months, and then chapter 13 is like 5 years, you're saying?
Yes, because that's the repayment plan.
Right. So chapter 13, that's what most people qualify for, and it's basically putting on like a repayment plan for all of your debt. Is that right?
Well, I would say most people actually, more people probably qualify for chapter 7. Chapter 13 is for people who have higher incomes and more assets. So it just depends where you are located. But I see more chapter 7s than 13s. But there are exemptions, and exemptions allow you to keep property. So that's another thing. Just because you file for bankruptcy doesn't mean you have to give everything up. Every state has exemptions that allow you to keep property up to a certain amount, a car up to a certain amount. So it doesn't mean that just because you're filing bankruptcy, you have to give up all of your assets. So it's really important to sit with an attorney to determine how much equity is in your assets and what exemptions cover those so that you're able to keep them.
Right. Okay, nice. Got a question coming in from Janelle. Hi, a debt consolidation company is paying part of my debt, but 2 creditors are suing me. Can I file for bankruptcy? I'm getting too much letters from the attorneys about a notice to admit.
Yeah, so the problem with debt consolidation companies is that they don't tell consumers that they have to fall behind on their debts and that usually they're trying to settle these debts. But while they're trying to settle these debts for you, that doesn't mean that the debt collectors are going to wait for you to come up with the certain amount of money to settle with them. And I see this all the time, that they don't tell you this, and the debt collector starts suing you. And yes, you can file for bankruptcy if they are suing you. Just because you signed up for a debt consolidation company does not mean that you can't file for bankruptcy. But it's really important for people to really do research before signing up for these debt consolidation companies, because a lot of people just are not good candidates for them. If you don't have the money and you're not going to come up with the money quickly to settle these debts, these creditors are going to sue you while you're in this plan. So that's really important.
Right, I'm still here. So having a little excitement. Let's see.
Also, it's a good idea if you are going to look into a debt consolidation company to really do your research. Look at the Better Business Bureau, look at reviews on consumer protection, in your state. Just do your research.
For sure.
Mm-hmm.
Great. Just having a little technical difficulty on my end. Going to backup camera. Great. All right, we got another question coming in from AI News. Can you file Chapter 7 bankruptcy on your own?
On your home. So if you file for
on your home.
On your own, yes. So you can do it on your own. If you have assets, I would advise against doing that on your own. But of course, you can go and download the petition and all the forms, I'm sure, at your bankruptcy court's website. But if you have assets, I would really advise not doing that because you really need to know what exemptions you can and can't use. So I would advise against that because if you file a bankruptcy and don't use the correct exemptions and you have property, the trustee can take your property. So I would advise at the very minimum consulting with a lawyer.
Okay, great. Nice. So in short, don't do it on your own, get a lawyer. Great. We got a question from Ron. If Midland Credit wins judgment against me in court, do I have a time frame I have to pay, or do they garnish your wages right away?
So I can't say exactly when Midland, once they have a judgment, is going to start garnishing your wages. But it takes a little while, but I don't know how long that little while can be. It could be a month, it could be 6 months. It's just up to when Midland and their attorneys decide that they're going to start garnishing. So you can always try to call them up. You could try to settle. Otherwise, typically in most states, you have to do a motion to vacate that judgment and then try to, get that judgment vacated and then relitigate that. Do you guys do that or no? I don't know. Do you guys do that or no?
Solo suit. Yeah. For solo suit, right. You can use solo suit to respond to a lawsuit. That's what most people are using us to do. If you have a judgment against you for like a default judgment because you'd never succeeded in like responding to the lawsuit, we do have a template you can use for a motion to set aside judgment or like a motion to vacate judgment, and then you can have us file that along with your answer. We have a pretty high success rate on that if you have a default judgment because you didn't answer. If you lost your lawsuit or if you got like a summary judgment, it's not going to work in that situation.
Yeah, so bankruptcy is an option in that situation if you can't, or otherwise you could try to call the creditor to negotiate a settlement. A lot of times they don't because they'd rather just take the wages at that point, but you never know.
Right. A question that we get from people generally is if someone sues, so let's say someone's been sued for debt, they come to solo suit, they want to respond. A question that they have is like, if I file for bankruptcy after I've been sued, will that stay the lawsuit, or should I respond to the lawsuit and then file for bankruptcy? That's a question people have.
So typically, to me, it doesn't. For bankruptcy purposes, it doesn't make a difference at that point whether you respond or not to the lawsuit. If you do want to respond to the lawsuit and give you some time to think about filing for bankruptcy, you can do that. Otherwise, you file for bankruptcy, it stops the lawsuit immediately. So the automatic stay, which goes into place, which is a law that says that once you file for bankruptcy, all collection activity must stop. That includes lawsuits that are pending in court. So that must stop immediately. So it's just up to you if you need more time to file and you want to file that answer so that you don't get a judgment. Otherwise, you could just file for bankruptcy and stop that lawsuit.
How long does it usually take from when someone decides to file for bankruptcy to when it's actually filed and that automatic stay is granted?
So obviously every lawyer has, the difference, but you could file a bankruptcy petition in a matter of a day or in a matter of a week. So if you have a pending lawsuit, the bankruptcy attorney should file it, as soon as possible to stop that judgment. Even if a judgment is entered, though, if you file a bankruptcy after a judgment is entered, you generally is still dischargeable in the bankruptcy.
And that's the same across all states?
As far as I know, it's the same. So
Great. Nice. All right. Janelle said, thank you. And keep the questions coming, folks. Love seeing the questions here. Almighty Streams, does Ohio have a law that prevents creditors from garnishing disability income?
So that I don't know. I'm not in, I don't practice in Ohio, so I'm not sure, but most states do have a statute that exempts Social Security benefits and disability benefits. Like in New York and New Jersey, they do. I can't speak directly for Ohio because I'm not licensed there, but there are a lot of exemptions for disability and Social Security that creditors can't get to.
Right. Okay. Are those exemptions usually those are just for Social Security disability? Are there other types of disability that people receive that might not be exempted?
Generally, it's mostly for disability and I'm just trying to think. Even military, as in New York, is like that as well. So most of them are exempted. Social Security. Obviously, wages. If you take out retirement accounts, those aren't going to be exempted. If you pull from the retirement account, but most Social Security is.
And Social Security, so that'll come in like a check, and then it gets deposited in your bank account.
Yes.
What about once it's deposited in your bank account? Do you think a collector would be able to garnish that? Your camera's drifting up. Your camera's drifting up on us. Okay, there we go.
So typically they're not supposed to garnish those. Sometimes creditors do, and if they do, then sometimes you have to put in a motion into court to show the court that whatever went in there was Social Security, so that they can take those funds. But typically they're not supposed to take those funds.
Right. But it might require a little bit of defense from the consumer to defend and protect those funds.
Correct. Right. Yeah. If they do garnish them, then yeah, unfortunately you're gonna have to show the court that it's all Social Security funds that they levied or took out of the bank.
Right. Nice. Great. And now's as good a time as any just to let you guys know a little disclaimer. Right. I'm not an attorney, so this is not a law firm. This webinar is not legal advice. Karra is an attorney. She's licensed in New Jersey. Is that right?
And New York. Yes, New Jersey and New York.
Great. But again, this is just a webinar. Shouldn't be construed as legal advice for any means. We got a question from Michael. I live in New York and I have about $50,000 in debt. My wife and I make about $97,000, and according to the means test, we make too much for Chapter 7. What are the odds of me still qualifying for Chapter 7?
Yeah, so I'd have to know more about your situation because there are different parts to the means test, and maybe you don't qualify originally, but maybe with taxes taken out, if you have cars, if you have dependents, we have to go through the means test and really see if you really don't qualify. Childcare, if you care for an elderly person, there's other parts to this means test that we could still try to go through and take it out. I don't know what those chances are without actually knowing more about your situation, but there is the first part of the means test that looks at the last 6 months, and then there's a second part of the means test that goes through your income and a lot of expenses that can be deducted off the means test. So we can go through that, and if not, then you may need to go into a Chapter 13 and get into a repayment plan.
Okay, so there's some possibility that you might qualify for Chapter 7 still, especially if you work with an attorney that can kind of figure out the proper levers to make the income work for it. Right.
Yeah, if we can, that's what we would try to do is go through.
Right. Okay, great. Another question from Janelle. What happens if an attorney filed an amended summons response and is not familiar with bankruptcy law? Can I switch to a bankruptcy attorney? Sounds like they're talking about an attorney for them, an attorney for the defendant.
Yeah, so yeah, you could always get a bankruptcy attorney. You could always hire a bankruptcy attorney and file for bankruptcy if that's what you want to do. Nice,
sweet. And I've put a link into the chat here for everybody. If you want to, if you need to respond to a debt lawsuit currently, or if you want to try to settle a debt lawsuit, you're welcome to use solo suit. We have a link in the chat that you should click on. It's a link specifically for Karra, so go ahead and click that link to get to our website, and then if you end up purchasing anything, if you end up using any of our services, just make sure you click that link to get in there. All right. Any other questions? Keep them coming into the chat. I've got a question here. I got sued and they served my grandmother at my old address. I'm a resident in a different state. Is there jurisdiction?
So in that case, you would have to file, well, I assume you could file an answer and state that they didn't serve you properly. If they already have the judgment against you, then you'll have to vacate on the grounds that you don't live there and that they didn't serve you properly. But keep in mind, they will a lot of times just refile the lawsuit and reserve you where you are. So I'm not going to tell you that that's, an end all, and that means that, they're going to stop, but that's a way to hold them off for a while, is if they didn't serve you properly. It's usually a defense to a lawsuit.
Okay, cool. Great. Next question here. How often do creditors sue?
So there's no amount of debt of when a creditor is going to sue. Obviously, creditors, just like consumers, take into consideration what their legal costs are going to be if they sue. The less the debt is, the less likely it probably is to sue. But they do end up suing it. I see it all the time that they do. I don't know how likely it is, but if the costs outweigh them suing, then they probably won't do it. But it's up to them. Right now, I've been seeing personally that debt collectors are struggling a little because consumers are racking up debt and they aren't able to pay them with the high interest rates. So I am seeing more debt collectors going straight for the lawsuit because they're struggling now. So I don't know how that's going to play out going forward. It depends on the economy, but it all has to do with that as well. Because if debt collectors don't get paid, then they're going to try to go through more forceful tactics to get consumers to pay.
For sure. Nice. Got a question from Sunny. My wife and I are being sued by Discover. We filed an answer. We are retired and I have been on disability. We have no income other than Social Security to pay them. Should we file for bankruptcy?
So in your sense, I don't know what state you're in, but it sounds like you may be exempt from them collecting against you. So you may want to go to court. Did they say they've got a judgment or not yet?
They don't have a judgment. We just filed an answer.
So you may want to file the answer and go to court and show the judge that you are exempt. If you are in your state, look up those laws to make sure you're exempt. And if you are, then you don't have to file for bankruptcy because you are exempt. But some people don't like to deal with the harassment of creditors and calls and all that. So some people, I've had elderly people say they just want to file for bankruptcy because they don't want to deal with it anymore. It's really, up to you. If you're judgment proof, which means that you have no assets for a debt collector to collect or against you, then technically you don't have to file for bankruptcy because there's nothing for them to collect on.
What do you mean by exempt?
So exempt meaning that you have no assets with equity or no assets that a creditor would want. So a house, a property, any property, a car. If you have nothing, or you have exempt wages, like we talked about Social Security, disability benefits, you're not working, but if you're getting 401k income that you took out, that can be garnished. So you just want to look at what your exempt income is and what is exempt in your state.
Okay, great. An exemption, that's not something that you formally file, is it? Or is that like a formal thing?
So they have different terms for different states as far as, what, I don't know exactly what it's called in the other states, but there is something, a motion that would be for exempted income, something like that showing the court that your income is exempt from garnishment or you're judgment proof, essentially, meaning that they can come after you, but you don't need to give up your assets to the
Interesting. That is
debt
something
collectors because
that is something that you can file in New Jersey.
yes, there is something that you could file as part of your answer. You could say that too, as well to the court.
Right. Interesting. Okay, great. We got a question from Lufa, or maybe Zulufa. If I want to settle, can I go straight to emailing the lawyer and make an offer, or do I still have to answer the court summons? I haven't received the summons. The process server was unable to serve me yet.
So you can always contact the lawyer to try to reach a settlement, but you just have to be careful of the date of when you're supposed to answer by. So if you don't get into some type of settlement with them prior, then you're going to want to answer. Also, answering gives you more time to negotiate a settlement, whereas you may feel pressured to negotiate immediately because if you don't answer, then they're going to get a judgment. So it just depends on how much time you want to give yourself.
So the ideal process is to file an answer. If you've been served, file an answer, and then you can try to settle.
Yeah, I would file an answer either way. I mean, it doesn't hurt you. It benefits you in any way.
What about the service process? It sounds like the person hasn't been served yet. Do you recommend, is it a good idea generally for people to avoid service, or should, if they know they're trying to be served, should they just make it easy for them to be served? Should they look things up online? What should they do if they know they're being attempted to be served?
To me, I think so I think that evading service isn't really going to be a solution in the long run unless they're serving you at the wrong address. But eventually, I mean, if they show good service, that they served you in some way or tried to serve you, they could still enter judgment. It happens a lot. So evading service is not really going to do much in the long run. Eventually, they're going to find you and get you. So I don't think, I think it's best to answer usually, I would say.
Yep, great. How does a C13 payment plan differ from any other payment plan? My problem is that my debt far outweighs my income.
So a Chapter 13 repayment plan is different, I assume, from like a debt consolidation. I assume that's what you're referring to. I'm not sure, but if that's what you are referring to, the interest and fees stop accruing in a Chapter 13. So that's a huge benefit because you're not paying interest and fees, and whatever your debt is now, that's what you're paying off. Also, depending on what payment plan you get into, you may not have to pay all 100% back. It depends on your debt to income ratio. So there is a plan that you come up with and propose to the court that will determine how much has to be paid back. So like I said, and another thing is that creditors can't sue you anymore when you're in a Chapter 13. So those are the benefits of bankruptcy versus just going into some settlement company and trying to do a repayment plan.
Okay, cool. All right. Thank you so much, Karra. That's all we got time for. Folks, thanks for being here. Very glad to see you all. Yep. And again, Karra is, what's the best way for people to learn more about your services or to find out more about your presence online?
I am on TikTok, the debt lawyer, but I also, if you want to send me an email, debtlawyer1@gmail.com, and my name is Karra Kingston. So I practice in New York and New Jersey, so you can look me up on Google. But yeah, I'm here to help anyone who's interested and who needs help with FTCPA or bankruptcy. So thank you.
Okay, great. I'll just put that into the chat here at the debt lawyer. Pretty straightforward, right? That is on TikTok.
Yep, and the email is debtlawyer1@gmail.com.
All right, thanks. Yep, we got lots of people coming in with saying thank you. All right, thanks, folks. And we will be back on here next week. And thanks for attending.